All right, it's 1:30. We'll go ahead and get started. Just some administrative notes. If you want to wear a mask, wear a mask. If you don't. I'm not going to make your personal health care decision for you. And with that, I'll take open announcements on the 1:30 docket. Mr. Castleberry.
Thank you, Judge. For a writ, for a bond reduction.
What page is it on?
That's a first page. Judge.
Got it right here.
Um,
Y'all have an agreement?
Actually, no.
All right, Chanel Miller.
Actually, Judge, she's in jail and she's in quarantine.
Oh.
So it looks like we're gonna have to bump that down the road.
All right. You want to reset it now? Yeah, let's go ahead and reset it now that we're going to lose sight of it.
I'm gonna be on vacation for the next 2 weeks, so the 25th.
That it? What day? I mean, what time? All right, I'm going to reset Chanel Miller for 9 o'clock on 11/27. Or is it 10/27? 10/27.
At what time, Judge?
9 a.m.
It's on the first page.
Don't get it here, dude. It's hot. Thank you. What else you got?
That's it, Judge.
All right, we'll see you. Yes, sir. Ms. Fallhaber.
Stevie Henshaw.
Stevie Henshaw. Let's see the docket sheet too. This cause number CR 20-0429-392, the state of Texas versus Stevie Henshaw. And this is set for status. Where are we at?
Judge, I recently received some plea offers, which I did convey to my client. I'd like some more time to discuss that. I don't anticipate she's going to take them though. However, I've also filed some pretrial motions a long time ago, before we had the multi-part suppression hearing. And I would just request a formal setting to take those up.
What are the motions?
There was a motion for fingerprinting for independent analysis.
Granted.
Okay.
I mean, if there's fingerprints, there are. If there's not, they're not. So, okay. What else do you need?
I think for today, that was it.
Okay. All right. Well, then, what's the offer? What's the latest offer?
The latest offer is a multi-part offer.
Let's talk about it.
5 years TDC probated for 5 years, or 8 years deferred adjudication probation, or 3 years TDC.
Okay. All right. Well, Ms. Henshaw, then the court is going to reset status to November 4th at 1:30. I'm not going to put you on the trial docket yet. However, I am going to order, you did test positive last time, I'm going to order you to take a drug test. Go take the test. When you get done, you know the drill. Come back in the courtroom. We'll go over the results together. You're not driving, are you?
No.
Okay. All right. See you here in just a little while.
In my plant yet, so I think I'll just, if I can, reserve until we recall the Henshaw.
Okay.
Thank you.
Mr. Stevens.
Yes, sir. Abraham De Silva. I should have looked on the list. Sorry, Jeff. I didn't even look at that list where I was.
I'll need to see the docket sheet on this. And this is cause number CR 21-0206-392, the state of Texas versus Abraham De Silva, set for status.
Yes, Your Honor, we have received an offer. My client has rejected that offer.
What was the offer?
1244A, 180 days county jail. And a new offer too, I think, reduction to 150 days county jail.
He rejected the offer back in September. So here's what I'm going to do. And we are, Mr. De Silva, we are really moving through these trials. Everybody's plea, and I think our last 2 jury dockets we ran because every case resolved. So I don't know where you are, but what I'm going to do is I'm going to put you on a trial docket. This is state jail.
Yes, sir.
And Mr. De Silva, I'm sure Mr. Stevens explained this to you, and I presume you nothing but innocent, but just so you'll know, if you do go to trial, the punishment range, if convicted, to be not less than 180 days or more than 2 years in a state jail felony. So you understand. All right, and he tested negative past couple times. I'm not going to test him. So, do we have a date to give him yet? Okay, yeah, he'll move up
For the
quick.
record, this is also enhanced, so it'd be a 2 to 10.
Oh, it's 2 to 10. So y'all have alleged 2 prior state jail felonies. And there's how much time, sir? How much time does he have already in jail?
I don't think he has much
Just
time.
a
sir.
few days, not long at all.
All right,
I'm not the same person that committed all the crimes when I was younger, sir. I've changed my entire life around. It's the only reason I haven't just took one of these offers yet.
I get you. They don't have to prove you're the same person. They just have to
Yes,
prove it
sir.
was you, that it's true that you have those prior convictions. So, all right, Mr. De Silva, then go ahead and keep in touch with your bondsman and your attorney, and you'll receive notice here in the next few weeks of when to reappear.
Yes, sir.
All right, we'll see you.
Kevin Compton, judge, motion to set bond.
Kevin Compton, come on up. This is cause number CR 20-0382-392, the state of Texas versus Kevin Compton, and set today, you said a motion to set, I've got reduced. Does he not have a bond?
I don't think there was a bond, judge.
Okay.
I'm almost positive there's not.
All right, and is the state ready as well?
Yes, Your Honor.
And are we going to hear testimony from your client for the limited purpose of bail?
Yes, sir.
All right, sir, if you could raise your right hand the best you can. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Now you can lower your hand. Mr.
Thank you.
Stevens.
Thank you. Please state your name for the record.
Kevin Compton.
Mr. Compton, as you heard, the judge said, we're here just to discuss your bond issue on this, not to get into facts of the case. You realize that?
Yes.
Okay. Tell the judge, how long have you been in jail?
6 weeks at this time and 2 months prior to previous.
Okay, this time was 6 weeks.
Yes.
Okay. And if the judge were to decide to set a bond for you, you have a place you would live, and if so, where would that be?
Yes, sir. I own my own house at 110 Dakota, and my girlfriend lives just a couple streets away. Just one of the 2 houses.
Okay, and do you have transportation?
Yes, sir.
And you're on disability income, is that correct?
Yes, sir.
And I believe you told me your income somewhere around 760 to 780 in that range.
Yes, sir.
And you also have, prior to disability, you had a handyman service, correct?
Yes, sir.
You got a bunch of customers out there still.
Yes, sir.
And so if the judge were to set a bond, would you be able to not only, post the bond and get out, but would you be able to work some of your handyman business again?
Oh, yes, sir.
You still got some of your customers.
I have quite a few customers.
Are you asking the judge to set a bond somewhere around the amount of about $10,000 to $15,000?
Yes, sir.
Is that amount of money that you think that your family and your fiance could raise the money to post a $15,000 bond?
It's just me and my fiance, but we do our best. In fact, sell stuff, tools or something, whatever.
Okay. Will you promise this court you'll appear
Yes,
if in
sir.
the event he sets a bond and you're able to affect bond?
Yes, sir. No, I'm gonna try.
That's what it's.
Yes, you said you do have a car to get to and from court?
Yes, ma'am.
Okay, it's a reliable vehicle.
Yes, ma'am.
Have you ever missed a court appearance before?
Yes, ma'am.
No further questions,
I see no bonded.
because he has a bond forfeiture.
I think because of bond forfeiture, Judge, I believe that's why there was a no bond. Originally, it was like an $8,500 bond or something. And it is,
The docket sheet.
it is a state jail offense. May I ask you a couple more questions, Judge?
Sure.
Thank you. When you failed to appear, you told me that you didn't receive notice about the court setting, correct?
Correct, sir.
Okay.
I have
And you've
Ma'am.
you've lived at the same address.
Yes, sir.
You haven't moved or anything like that, correct?
That's right. Give the same address.
Okay. That's good, Judge.
State, any recross based on that redirect? Anything else?
No, Your Honor.
And he said he didn't receive notice.
That's what he
Was that
said.
an
Just-
arraignment? Was that an arraignment?
It,
So at arraignment, I look them right in their eyes and I tell them when their next court dates are. And then they receive it in writing.
I will receive it, sir. Even my probation, my parole officer.
Do y'all have a reset notice in from that August the 6th, 2020 date? A carbon copy of it?
Judge, I've got a reset notice, but it was from this last court setting.
I was gonna say, I have the reset notice from the last court setting.
I don't have prior reset notices.
I
in
don't
here.
either.
Well, doesn't the state normally keep those? How about the clerk's office in the file? You wanna see it? I'm sorry, not from August 6th, but from the, when was he arraigned? What date was he arraigned?
That would have been
September 2nd.
July the 2nd, I believe, or September the 2nd.
So that was
I
his,
have- Your Honor, I have a notice here saying on August 6, 2020, he did not show up.
right, but that was for arraignment. Is that
That
correct?
is correct.
Okay, it makes a difference if it's for arraignment. All right, well, then the court's going to grant the motion to set bond. The court will set bond at $20,000 surety bond. And to be clear, he didn't show for arraignment and then his bond was forfeited. It's not like he was arraigned and then reset.
That's correct.
I believe that's correct, Your Honor.
And of course, let's see, Mr. Compton, conditions of bond will be no alcohol, no drugs not prescribed, no illegal drugs, and no THC, marijuana, Delta 7, whatever that nonsense is. None of that. All right. And you already do have conditions. I'm just reminding you of them.
Thank you, Judge.
Right, and if somebody will get me an order, actually, there's an order right here. All right, thank you.
Thank you, Judge.
Hold on, do we need to reset him? Before we go
It's
anywhere?
already set, Judge. in,
When is it?
November the 3rd, I believe.
I need to know for sure.
November
That
3rd.
is
Yes, sir.
November 1st,
November
and
3rd.
December 3rd.
You're saying first, you're saying third. When is it?
It's
11.
November 3rd.
Yeah.
What time?
1:30.
November 3rd, 1:30. All right, thank you, sir. Mr. Green? You next? It's Melontree. Good, how are you? Let's see, when we get there.
We on page 7.
Mr. Moore, come on up. This is cause number CR 20-0395-173, the state of Texas versus Demetrius Moore. And that is set today for status. That's a different one. That's in the wrong cause number.
Oh, sorry.
And speaking of judges, the court's aware, Mr. Moore has another case with a different attorney. Standing in for Ms. Palmer, she told me that that other case with Ms. Wiley, apparently Ms. Wiley's health is improving, and I think they have an agreement to try that in January.
Kevin, did we not have a, sorry, I just need to get through this. Did we not have a different date for Demetrius? So she did do January? I thought I thought it was later than that. Oh, that's right, we said it number 2. Okay. Well, here's the deal, though. I mean, if Miss Wiley can't go in January, this case is gonna go on the trial docket. And if this case gets tried first, it gets tried first. Because they're 2 totally unrelated cases, from
Right.
my understanding.
But when we were talking to Ms. Palmer,
Mhm.
she was telling me if I got her some information prior to the trial date, can we take it off the trial docket and plead?
Oh, that's between
Okay,
y'all, but
good.
what I'm gonna do is I'm gonna deem status as held, and we're gonna place this case on the trial docket.
Oh, that'll be good, Judge.
And so wherever it ends up, it ends up. And just like the other gentleman, we don't have it yet. So Mr. Moore, just stay in touch with Miss Mellentree, Miss Wiley, and your bondsman. And you'll receive notice. You already set in January. What date is that? Pre-announcement?
I want to say the 15th. It's the 10th. Oh, wait,
5 days.
the 10th is,
So January, we will see you January 10th at 9 a.m. on that case, unless you hear otherwise. That's your other case. And on this case, you'll receive notice here in a few weeks of where you're at on the trial docket. And so as soon as you receive, but you don't need a reset notice on that one. So we'll see you in January if I don't see you soon.
We'll be here soon.
All right, good to see you.
Good seeing you always, George. Have a good
You too.
Halloween.
I'll try. I'm dressing up as a job application. I'm going to scare a bunch of people. Yes, ma'am. Mr. Green?
I've got it. Judge Tara Lockhart.
I got it. Tara Lockhart.
Judge, what happened is last month, she was in the hospital, and she wasn't here. She provided verification to me. It took a while to get it. I have it. But it wasn't a reset notice done when we were here last month. Not sure why, but it came out on the big docket or the multiple dockets that Kevin sends us the emails on right the week before court. She was on that docket. I sent her notice. She has notified me today that she cannot be here. To be candid with the court. But in checking with the file, it doesn't appear that other than the notice that I've provided her, she was given notice by the court. Or so
What do you want me to do?
I think she needs to have proper notice before bond forfeiture can be done.
Let's set her for November 4th at 1:30.
And I presume
Yeah.
The November 4th at 1:30.
Yep, for pretrial. Ms. Henshaw, you passed your test. You're free to go. What else you got?
Holly Goff, Judge, bottom of page 3. Just for the record, that's one that TDCJ would not honor the bench warrant because somewhere along the way, she's no longer Holly Goff, but Holly Cheatham, something like that. And so she is in the Marlin unit.
Yep. All right, let me call it CR 20-0447-392, the state of Texas versus Holly Goff. Ms. Goff is currently incarcerated in the Marlin unit and did not honor our bench warrant because she has a different last name. Can y'all run a 27, 23, whatever? 27?
I think she's apparently booked. She's in the custody of TDCJ under the last name of Cheatham. In fact, we had a
Actually, that'd be the easier way. Go to VineLink or the TDCJ locator. Whatever last name she's listed under, issue a bench warrant and I'll sign it.
Yes, sir.
And we'll set it for November 4th at 1:30.
Apparently, a couple of months ago, she was in Bear County's custody and they booked her in under that name and we couldn't even find her for
Okay.
a period of time. Jennifer Vandiver on page 4, Judge.
Jennifer Vandiver.
This is one that I talked to Mr. Inslee in the court yesterday about. She's been exposed to COVID. Court asked me to get, she's been exposed, although has not tested positive. It's her daughter who she lives with. She emailed me this morning, and I can, as officer of the court, can tell the court I had a positive test of her daughter dated 10/4 on my phone, but I haven't been able to go to the office
She
today.
can't zoom in.
Well, I think Mr. Inslee indicated that,
Oh, is this the one that we,
If they have an excuse, no, then let's just push it to the next day, because you're not gonna get anything done.
but this is such a can of worms. But exposed, we've all been exposed to COVID. It's been around forever.
well,
Either you've had it, you've had the virus, or you're going to get it.
I understand.
You're going to get it. And you may not know it.
Well,
But-
no, that's how I got it, so
I got it. I'm naturally immune for
Uh,
life now.
hopefully we are.
No, we are.
So I will email either later today or in the morning, the notice to Mr. Inslee. I
November
think
4th,
I need to do
1:30.
some redacting on it because she sent it to me
Sure. that's-
without,
I trust. November 4th, 1:30.
thank you, Judge. Randy Earwood, Judge.
Mr. Earwood's here.
He is here, Judge.
All right, it's cause number CR 21-0082-392, the state of Texas versus Randy Earwood, set for status. Where we at?
Judge, Ms. Carpenter and I talked this morning. Apparently there may be some new discovery that they need to provide me. Also, I do have an investigator that is working on interviewing a couple of fact witnesses in the case. He is also the investigator in that capital murder trial in Smith County right now with the nurse that supposedly killed 4 or 5 people. And we just need a little more time to get, we've been talking about resolutions. Don't know if we're going to get there, but need to have a complete investigation
What's
from
the
our
dis-
side.
Oh, sorry. What's the discovery?
Today, we just received some jail mail that included one of the witnesses in the case.
Copies of jail mail or jail mail was sent to y'all?
No, it was copies.
I mean, that's the thing about, I mean, I understand the investigator thing about calls and jail mail is it keeps going all the way up to the eve of trial. And so sooner or later, you got to cut them off.
Well, state's ready, Your Honor, except for, I know he has an investigator. So.
Okay. I'm just going to reset status on November 4th then.
Thank you, Judge. And I think,
But if it's his jail mail or his calls, well, then he already knows what was said.
I agree, Your Honor, but I want to provide him a copy.
I think we do, but
Okay.
I discussed it with him before we came up here, so I think we know what it is, but we still need to do our part on
Well,
the witnesses.
Based on the investigator still working on witnesses, I'll grant another status for November 4th at 1:30. So we'll see you November 4th at 1:30, Mr. Earwood. Thank you. Yes, sir.
So it's still working on the others.
Okay.
Thank you.
Mr. Scott?
I've got John Doty for status.
All right, it's cause number CR 19-0279-392, the state of Texas versus John Doty, set for status. Where are we at?
Your Honor, I was appointed to replace Mr. Kittles. This is the very first time I've ever appeared in court with
Okay.
Mr. Doty, and he was bench warranted from Dallas. I just met him for the first time earlier this week. I was gonna see if we could set up a pretrial. I don't have, I've got some police reports, but I don't have any audio
How
recordings.
about I do this? How about, matter of fact, I just visited with Mr. Skittles last week. He looked good. How about we just back this up, reset it for discovery status on November 4th at 1:30. That way we can make sure you have everything. And then if you need more time for, we'll set a pretrial after that. Does that work?
Okay, that works, Your Honor.
Mr. Doty, you're the one in jail. You're all right with that? Give your attorney time to get up to speed. When did he get back from Dallas County?
When did you get back?
September 23rd,
Whose food's better, us or Lou Sterrett?
Peterson County.
Okay, good, good. I'll let the sheriff know that.
Appreciate it, Judge.
We have a lot of people in Lou Sterrett right now. All
That's all I got, you know.
Yes, sir. Ms. Paul Haber.
Thank you. Misty Green. You're gonna have to-
I'm trying to find her first. Here's- Misty Green, is this for a police,
It was, I don't think she's here.
for jail time? There you go. Man, this is,
Is it a recurring theme?
this morning was not too bad, this afternoon. Cause number CR 21-0209-173, the state of Texas versus Misty Green. Is there a Misty Green in the courtroom? I see no one. I hear no answer. There is not a Misty Green on Zoom. Her name was called 3 times in the lobby. She was set for a plea to do jail time today at 1:30. The time is 1:56. The court will entertain a motion. Granted, capious issue shall be held with no bond.
That is his-
Yes, ma'am. And Ms. Henshaw passed her test. I don't know if you were in here. When I told her.
Yes, I was. Thank
Okay.
you.
Mr. Weiner.
Yes, Your Honor, page 5, Jack Riskin.
These are cause numbers CR 21-0144, 45, and 46-392, all three styled the state of Texas versus Jack Riskin, and all set for status.
Yes, Your Honor. Mr. Head informed me that Mr. Riskin had some significant health issues. He had COVID and had infections in his knees, and he needs some time to go over the discovery, relay offer, and make a decision. So we're asking for an additional status. I know the court's position on statuses.
No, I saw on the docket sheet, he was, I guess, in the hospital or sick the last time. So, all right, Mr. Riskin, I'm going to reset your status to November 4th at 1:30. Okay, so we'll see you then. And you tested negative the last couple of times, so I'm not going to go test you today.
May he be excused.
Yes, sir. You're welcome.
And then page 4, Tristan Lori.
Kristen Lowry. Lowry. Larry. Larry. Like Larry. Like Larry.
Sorry.
All right, it's cause number CR 21-0455-392, the state of Texas versus Tristan Lowry, and that is set today for status.
Yes, Your Honor. I spoke to Mr. Head. I kind of the same announcement. He wasn't ill, but was asking for an additional status to.
Where's
talk.
Mr. Head at?
He's out of the office today.
He hadn't, we're at status, he hadn't communicated the offers.
I think he has. I just think he wants some additional time.
All right, and then Mr. Lowry, then the court's going to reset status to November 4th at 1:30. I'm going to order you to take a drug test today. You'll go take the test. When you get done, come back in the courtroom and we'll go over the results together.
Unexpected kids. or something like that. So sorry about that, Judge.
Ms. Moore.
I can take them in order. I'm not sure who's first.
Porter Lane. Porter Lane. What is it? Cause number CR 21-0427-392, state of Texas versus Porter Lane, set for status.
Your Honor, we do have a offer for 3 years deferred probation, which Mr. Lane does not wish to accept.
Okay. I see the docket sheet. All right, well then, Mr. Lane, I'm sure that Ms. Moore explained to you that if you do, you have, I presume you're nothing but innocent as you stand there, but if you go to a jury trial and the state proves this case beyond a reasonable doubt, then deferred would be off the table after a conviction is made. You understand that? In other words, you couldn't get deferred because I can't defer a jury's finding of guilt. You understand that? If you, again, that's if they prove their case beyond a reasonable doubt. However, I am going to order you to take a drug test today. You'll go with probation, take the test. When you get done, come back in the courtroom and we'll go over the results together. And I'm going to put this on the trial doc. Actually, I'm going to reset status. I'll reset it to November 4th at 1:30. Give you all one more opportunity to
Yes, thank you, Jen.
reach an agreement. If you can. If not, then we'll put it on the trial doc. And next you have Mr. Walters, who's in custody in Kaufman County.
That's correct.
And so we're going to reset CR 21-0094-392, State of Texas versus Trey Walters. We'll reset that case to November 4th at 1:30. And if y'all get me a bench warrant from Kaufman County, I'll sign it. Next is Jason White. This is cause number CR 21-0364-392, the state of Texas versus Jason White, set for status.
Your Honor, we haven't been able to resolve Mr. White's case.
Do y'all have an offer?
We do have an offer. The TDC offer, he rejects. The state, we're still talking about maybe doing an open plea. So we know we don't want to accept a TDC plea. There is an offer for an open plea with a cap. But he's not rejecting that, but we don't have a plea bargain to present to the court today.
So he doesn't know whether he's gonna do the open plea or does he?
Not at this time.
How about I reset it for November 4th?
That'd be
Is
fine.
that fine with you, Mr. White? Or I can put it on a trial docket, or do you want one more shot at it?
We really would like a shot at probation. So we're.
I'll set it November 4th at 1:30 for another status, and if we don't resolve it then, I'll put it on the trial docket.
Trying to wear Miss Colts down, but so far it hasn't been working.
All right, we'll see you back on November 4th at 1:30, Mr. White. All right, thank you.
If I could step aside for Mr.
Yes,
Lane.
sir. Yes, ma'am. Mr. Mills.
Page 7, Garcia.
Manuel Garcia. These are cause numbers CR 21-0088, 8990 -392, all three styled the state of Texas versus Manuel Garcia. Set for status today. However, a plea has been presented to the court. Is the state ready? It's okay. I'll sign the paperwork. Take your time. Y'all ready now?
Yes, sir.
Mr. Mills, you ready?
Yes, sir.
Sir, is your name Manuel Garcia?
Yes, sir.
And are you the same person that was originally indicted by a Henderson County grand jury for this second-degree felony offense of possession of a controlled substance?
Yes, sir.
I can get you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Garcia, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Garcia, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on here?
Yes, ma'am.
Mr. Mills, do you believe your client is competent?
Yes, sir, he is.
The court finds that he is. Mr. Garcia, I know that we've already arranged you on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
No, Your Honor, wouldn't like that.
Do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a second-degree felony, which carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand that range of punishment?
Yes, sir.
In the plea bargain?
The state is recommending 5 years deferred adjudication of probation, taking into consideration an indicted tampering fabrication charge and an indicted PCS charge. This would be an $800 fine, $180 lab fees, and all standard and special terms and conditions of probation.
Is that your understanding of the plea bargain, Mr. Garcia?
Yeah, Judge, actually, that was incorrect. There was it was written down wrong on the plea papers. I changed that. There were 1245 in a tampering case and 1245 in an evading arrest case. He's
I see
pleading
it.
to the
Yeah, I see it
PCS
on there.
case.
Okay. All right, with that, and that changes on the on the plea sheet. Is that your understanding?
Yes, sir.
Is that your understanding, Mr.
Yes, sir.
Mills? Well, Mr. Garcia, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over that with Mr. Mills,
Yes, sir.
both the front and the back?
Yes, sir.
And did you sign it?
Yes, sir.
Do you have any questions about it?
No, sir.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
And did you sign that second page?
I did.
Do you have any questions about it?
I don't.
Do you have any questions about any of the documents that you read and went over with Mr. Mills?
No, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir. I don't.
Do you want to do this plea bargain?
Yes, sir.
And I'll ask you, sir, how do you plead to that second-degree felony offense of possession of a controlled substance as alleged in the indictment? Guilty or not guilty?
Guilty.
Are you pleading guilty because you are and for no other reason?
Yes, sir.
I'll hear the evidence.
The state presents states 1, the offense report, states 2, Michael Moore compliance, and states 3, lab report, Your Honor.
No objection.
Admitted.
State rests and closes, Your Honor.
Yes.
All right, Mr. Garcia, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court will defer making that finding, follows the plea bargain, takes into consideration these 2 indicted cases and punishing you, places you on 5 years community supervision. How many days credit does he have? It's not listed on here.
How long did you spend in jail when you got arrested? Probably a day. You bonded out the next day? Yes, sir. Probably got a day credit, then, Your Honor, maybe 2.
We got to get that straight. This is on the PCS. April 26, 2020, is the offense date. You're right. Feels like a Monday.
2 days.
2 days credit. So you do have 2 days credit as to any sentence you may eventually have to serve. Orders you to pay your fine, attorney's fees, court costs, and lab fee, as well as abiding by all these special terms and regular terms and conditions of probation. Mr. Garcia, have you ever been on probation before? Do
No, sir.
you know what can happen to you if you violate this probation?
Go to jail.
All right. Well, there's lots of things you have to do and a few things you can't do while on probation. In your case, since this is deferred, if you were to violate any term or condition of this community supervision, a motion could be filed. A warrant would be issued for your arrest. You'd be brought back before the court. And if the court found it were true that you violated even one term or condition, the court could find you guilty, revoke your probation, and you'd be subject to the whole range of punishment, up to 20 years. You understand that? So would you agree with me? It's extremely important you abide by these terms and conditions. I hope you do. Good luck to you, sir. You need to see probation before you leave.
Thank you, Judge.
Yes, sir. You're welcome.
Jack Rayburn.
Jack Rayburn. All right, this is cause number CR 21-0418-392, the state of Texas versus Jack Rayburn, set for pretrial. Any pretrial from the state?
No, Judge.
Granted, and on behalf of Mr. Rayburn.
Judge, we were here for maybe pre-trial last time. I filed a motion for speedy trial on behalf of Mr. Rayburn. And then I also filed, he indicated he wanted to ask the court for another attorney. So I filed a motion to withdraw. We're just not communicating at all.
All right, Mr. Rayburn, I'm going to place you under oath. I'm just going to ask you questions about this motion, not anything about this alleged offense, okay? All right, can you raise your right hand? You probably already have it raised, couldn't see it. All right, you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Now you can lower your hand. Now, Mr. Rayburn, what's going on with this?
I've gotten him on the phone 2 times in 6 months. I mean, this is, I'm up here fighting for my life, you know what I'm saying? I need to be able to.
Everybody in here is, yeah.
I mean, it's a lot more serious, I believe, most of them, but, I mean, I asked you to file a motion to speedy trial. I wanted you to look at the evidence. I mean, we've been here 7 months.
You
and,
can't look at the evidence until you go to trial unless there's a motion to suppress or something.
That's what I'm saying. I asked him last time I was here last month, why I didn't file the motion to suppress evidence. 'Cause I want you to look at, I want you to look at the case and rule on it, man. I mean, I know I didn't do it.
Well, I mean, on a motion to suppress, the only thing I can do is suppress the evidence if it was gained in violation of a particular statute or it's unconstitutional.
I mean, I ain't seen no evidence. I've been locked up 7 months.
Well, and I understand, and I know we've got a long docket here, but there is a rule that the defendants fought for. It's called 3914, and it precludes Mr. Mills or any defense attorney from giving you a copy of the offense report. He cannot give you a copy of the offense report. He
I
just
know y'all
can't.
can't produce the evidence to convict me. I know that. My wife's gonna have her lung taken out of her body.
Yes, sir.
50-50 chance she's gonna make
I understand.
6 months to live. You know what I'm saying?
So you want me to grant you another attorney?
Yes, sir.
Well, I mean, every attorney on this wheel is a good attorney. I've personally been in trial against Mr. Mills, and he'll make you work your butt off if you're the state. I'm gonna tell you that right now. But what I'm gonna do is I'm gonna grant, I guess you filed this complaint, so I'm gonna grant his motion, and then we'll figure out who's next on the list.
Thank you, Your Honor.
Yes, sir. And so before you leave today, we'll know who it is.
And I was talking to Justin Weiner, the funds, I'm trying to put the funds together, but I mean, it's been a little, I mean,
Do you want me to hold off and see if you can hire him, or do you want me to go ahead and appoint now?
do I gotta do a whole month before I come back, or can I come back sooner than that? I mean,
What do we got? We'll bring it back next
That's
week.
fine, that's fine,
Let's
sir.
do that. I'll grant his motion. We'll bring you back on November or October 13th, 1:30.
appreciate it.
Yes, sir.
We're just gonna call out attorney status, Judge,
I'm just going to call it a status.
1013.
Yes, sir. I'm getting my dates mixed up now. You get that reset notice, you can have a seat. And Mr. Rayburn, we'll see you on the 13th. Yes, sir.
Willie Thomas.
Willie Thomas. All right, these are cause numbers CR 21-0111 and 0474-392, both styled the state of Texas versus Willie Thomas, and both set for status. Where are we at?
Judge, they've made a 24-month state jail offer. We're still negotiating. We're set for suppression hearing. I can't remember what day it was now, October the 27th. However, hopeful that we can get it worked out. If the court, I think I talked to Mr. Cox a minute ago, and I think they're gonna do some checking, and if we could maybe set it next week or another status, and then we'll know if we can pleading or
Or we need to
leaving.
go. Okay.
I think there's a pretty good chance we'll get it worked out.
October 13th? October 13th, 1:30. Mr. Thomas, you're the one in jail. You all right with that?
Yes, John.
All righty then. We'll see you next week.
Floyd Smith on page 8.
Mr. Smith. What up, Mr. Smith? I did physical activity at once. I'm sweating still. Hosing down on this is old driveway. We got new concrete. Sun. Hot. Okay. All right, this is cause number CR 21-0497-392, the state of Texas versus Floyd Smith, set for status.
Which I think the offer was 10 years, I believe, and he does not want to accept that. I don't think it's long gonna be able to get worked out.
All right, Mr. Smith, then the court deemed status is held. Your case will be placed on a jury docket. What's the, is there any enhancements? I want to know what the range of
Yes, Your
punishment
Honor,
is.
we have two enhancements, so it's 25 to 99 life.
Okay, so Mr. Smith, and I know Mr. Mills explained it to you, but I just want to explain to you that you will get a jury trial, and if the state proves their case beyond a reasonable doubt and then proves these two enhancement paragraphs true, then the limit or the minimum punishment will be 25 years, max up to life. You understand that? Okay. All right. Well, then remember any conditions of bond you have. I'm not going to give you a reset notice now. Stay in touch with Mr. Mills and your bondsman.
He's been good about that. So.
Yep. And then here in the next couple of weeks, you'll receive a notice on when to appear for a jury docket. All right. Thank you, sir.
I think I just have one left, and we're still working on him.
Got a plea on Jesse Webb?
Yes, sir.
All righty. Sir. Michael Berry. All right, these are cause numbers CR 21-0459 and 0855-392, both styled the state of Texas versus Michael Berry. And the 855 is set for arraignment. Mr. Harrington.
Yes, sir. In this case, Mr. Berry has reviewed the indictment. His name is spelled correctly. He understands the charges in both paragraph A and B, and we will. He's also reviewed the enhancements paragraph. We'll waive the formal reading and plea of not guilty to paragraphs 1 and 2 and not prove the enhancements.
All right, Mr. Berry, the court notes your pleas of not guilty as well as your plea of not true for purposes of arraignment. And then, do we have an offer to wrap all this up now?
There is, Judge.
And what's the offer?
20 years on CR 21-459, 12.5, CR 21.
Okay, all right, so here's what I'm gonna do then. Mr. Harrington, is that right?
Yes, sir.
Okay, so what I'm gonna do, Mr. Berry, I'm gonna let this new case catch up with the old ones. So I'm gonna reset status on 459. And then your next two court dates on the new case are December 1st at 9 a.m., which is when I'm gonna reset that status case to. And then on January 5th, 22 at 9 a.m. for pre-trial. So as soon as you receive that reset notice, sir, you can have a seat.
Christopher Morgan.
Christopher Morgan. This is cause number CR 21-0895-392, the state of Texas versus Christopher Morgan, set for arraignment. Mr. Harrington.
Your Honor, Mr. Morgan has reviewed the indictments. His name is spelled correctly. He understands the charges contained in the indictment. Will enter a plea of not guilty and not true to the enhancements.
All right, sir, the court notes your plea of not guilty as well as not true. For purposes of arraignment, your two next court dates are December the 1st at 9 a.m. for discovery status, and then again on January 5th of 22 at 9 a.m. for pretrial. So you're going to receive that reset notice, and if you get out of jail between now and December 1st, I need to see you back here on that discovery status date. All right, as soon as you get the reset, you can have a seat. Thank you. Yes, sir.
Travis Thorson on page 6.
Mr. Torgerson. It's cause number CR 21-0932-392, the state of Texas versus Travis Torgerson, set for arraignment. Mr. Harrington.
All right, Mr. Thorson informed me today as well as other occasions that he wished to have another attorney to represent him. He tells me he's filed a grievance with the state bar of Texas, but I haven't received it.
I just appointed you.
Yes, sir.
Okay, now here's what I'm gonna do. I'll take it under consideration. Once I see it and review it, Mr. Torgerson, I'm gonna enter a plea of not guilty on your behalf, and I'm gonna reset your case
Your Honor, he's also got some
To,
motions that need to be filed. too,
December
sir.
1st at 9 a.m. for discovery status.
Okay.
And then again on January 5th, 22 at 9 a.m. And on December the 1st, I'm going to take up, or if I don't
Your Honor, is
forget
this
it
your
before
signature
then,
right here?
before
Does it say
December
Robert
1st.
McGee on this motion, sir?
It sure does.
Okay, can you explain?
So
to
I'm
me
not going to answer any more questions. Have a seat, Mr. Torgerson. I'm tired of dealing with you.
what
No
person
more.
of the grand
Get him
jury-
out of here. Take him out of the courtroom.
He's fraud.
Every time I bring you in
Fraud.
here, you're talking, you're calling every attorney in town, go.
I need my paperwork.
December 1st, January 5th, 22, 9 a.m. Sorry, he just doesn't let, can't do anything. What else you got, Mr. Harrington?
Ashley Haley, apparently she's on Zoom.
I got her right here.
Hello.
Miss Haley, let me get to your case. Hold on just a second.
Yes, sir.
All right, this is cause number CR 21-0491-392, the state of Texas versus Ashley Haley, set for status. Where are we at?
Your Honor, Haley has been in Dallas on the phone. I relayed the offer to her. I believe she did not want to accept it. Is that correct, Miss Haley? Did you not want to accept the plea offer we talked about this week on the phone?
Is that the one that we were talking about, like going to trial?
Well, it was the probation offer to accept your, not have a trial, and you want to have a jury trial. We spoke about it this week on pages.
I'd like to plead not guilty, and try to have a jury, or if we can reset it, I can come down there. We're getting a car within this next 2 weeks.
Why is she on Zoom?
Your Honor, it's my understanding she's in Dallas and had no transportation.
Miss Haley, you were directed to be in court, not via Zoom.
Yes, sir. I was trying to get a hold of anybody and everybody, but as of right now, we're in a homeless shelter called Family Gateway, and they couldn't provide me a ride. I tried calling.
Hold on a second. Where are you at?
Family Gateway Homeless Shelter in Dallas.
Okay. I'm going to reset your status to November 4th at 1:30.
Yes, sir. I will be there. We will
Okay.
have a
Do
car
y'all
by
have
then.
any, do y'all have any felony convictions you have alleged against her? Liars?
I don't believe so. No, I'm
Miss Haley,
Yes, sir.
you can't even go to a restaurant around here half the time because people are looking for people to work. I talked to a restaurant owner just yesterday over here at Benson's, and she can't even hire people to work. And so there's lots of jobs out there. You go out and work a job, you might have a little bit of gas money. I'm going to reset you to November 4th at 1:30, and I'm going to require you to appear in person unless you have a positive
Yes, sir.
diagnosis for COVID.
Yes, sir.
I'll see you November 4th,
Yes, sir. At what time?
1:30.
Yes, sir.
All right, thank you.
Thank you.
Is that all you had, Mr. Harrington? Mr. Green? Yes, sir. Thank you. All right, it's cause number CR 20-0235-392, the state of Texas versus Michael Cernot, and that is set for status.
It's actually set for a status hearing, Judge. We do have a trial date for December the 13th, and you just wanted to keep it.
I got you.
Keep it on the docket, to keep it moving along. And that's, we're moving along, should be ready on December 13th.
Okay, are we going to need to hear any prolonged eve of trial motions or anything?
I don't think so, Judge.
Okay.
Honestly, I haven't really thought about that yet, but I don't think there will be.
And is jury selection on the 13th?
Yes.
The announcements, December 6th.
Okay, so we do have a date between now and then.
Yes.
Okay, all right, so Mr. Cernot, what we're going to do then is I'll see you again on December 6th for announcement. He's number one on that trial doc, is that right? All right, and so as long as nothing happens between now and then, we'll see you on December the 6th for announcement, and then we'll pick a jury December 13th at 8:30. All right, thank you, sir. You can have a seat as soon as you receive your reset notice. Anything else ready? Here's what I'm gonna do. I'm gonna go through the docket for those that have not been handled yet. If you hear your name, just let me know you're here. Zachary Crawford. Okay. James Sockwell. I got you. Getting ready to talk to the attorney. Okay. Douglas Eaton. Douglas Eaton. This is cause number CR 21-0172-392, the state of Texas versus Douglas Eaton. Is there a Douglas Eaton in the courtroom? Oh. What are we doing with Mr. Eaton's case? Okay. Amanda Baldwin. Okay. Murray Frank.
Right here, sir. Judge, we're working on some plea papers.
Perfect, gotcha. Amy Bookman. Gotcha. Sabrina Joliffe. Oh, okay. Do they know that? Okay, I'm just gonna take her off. Jesse Webb's gonna be a plea. And let's see, that's it. All right, we'll go ahead and take a recess. Y'all let me know when we got something ready. I'll give you my Robert McGee.
Okay, whichever.
I was just trying to get the, I want to finish going through the folders with the TRNs that were behind the desk. And so I had to and finish some and wanted to let Lori and Jill know because they have to do it. Sending that to the, oh, no, the reinstatement. So we're good on that. Well, I haven't got any responses, but I sent it to the caption. Better on that. Yeah. So, we get a response. Pretty much probation, so that's the thing that early, it's not early, the fines are paid for
Bill, Carter.
family. Purple shirt. Purple shirt.
Yeah, I know.
Oh, okay. I was like, I don't have, I was looking to make sure, I was like, I don't see any more pages. The problem is, I don't think did y'all take it off? Yeah, I think it off. Oh, off here. Well, I have one in here for her, but I didn't know she had another. Yeah, it's the old attachment. So they've actually. I don't know if the judge is what.
Yeah. Yeah. Right. Yeah. I just put dialogue. It should be, if I log out, it should still say. So I think we'll be okay. I've already put my application in. I've been recording 16. Oh, yeah. Yes. You already did that. Oh, yes. Yeah. I was like, where did this all here go? Because I knew he was here somewhere. No, it's not. Yes, I have this. Yeah. Yeah. Exactly.
All right. John, keep your seats, keep your seats. She had texted me. Okay, we'll take care of you. Here. Oh, yeah. Mr. Mills.
Jesse Webb, please.
Webb, come on up. You're all right. All right, this is cause number CR 21-0110-392, the state of Texas versus Jesse Webb. And this is set for a plea today. Is the state ready?
Yes, Your Honor.
And on behalf of Mr. Webb,
We're ready, Judge.
all right, sir, is your name Jesse Lee Webb? And are you the same person that was originally indicted by Henderson County Grand Jury for the state jail possession of a controlled substance?
Yes, sir.
And get you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Webb, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
Got to ask that everybody, Mr. Webb. Mr. Webb, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here?
Yes, sir.
And let's see, so just a regular probation deferred?
It's a deferred, 3 years deferred.
Yeah, I don't need the ammunition. All right, and Mr. Mills, do you believe that your client is competent?
Yes, he is.
And the court finds that he is. Mr. Webb, I know that we've already arraigned you on this case. However, would you like the state to read the indictment out loud here in the court?
No, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a state jail felony, which carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine of up to $10,000. Do you understand the range of punishment?
Yes, sir.
In the plea bargain?
The state is recommending 3 years deferred adjudication probation, credit towards any future sentence of 125 days, $650 attorney's fees, $365 court costs, 180 lab fee, all standard and special terms and conditions of probation, and this offer, or this would be taking into consideration a prohibited weapons case for 2020.
I've got 900 attorney's fees.
Yeah, no, it should be 900.
Okay.
Yes, sir.
And with that change in the attorney's fees, Mr. Webb, is that your understanding of the plea bargain?
Yes, sir.
Is that your understanding, Mr. Mills?
Yes, Judge, it is.
Well, Mr. Webb, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation.
Yes, sir.
Did you read and go over both the front and the back with Mr. Mills?
Yes, sir.
And did you sign the front and the back?
Yes, sir.
Do you have any questions about it?
No, sir.
The next document I'm going to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
Did you sign the second one there?
Not really.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with Mr. Mills?
No, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury.
Yes, sir.
Do you want a jury trial?
No, sir.
You want to do this plea bargain?
Yes, sir.
And I'll ask you, sir, how do you plead to that state jail felony offense of possession of a controlled substance? Are you guilty or not guilty? And are you pleading guilty because you are and for no other reason?
Yes, sir.
I'll hear the evidence.
The state presents the offense report as states 1, the Michael Moore compliance as states 2, and the lab report as states 3, Your Honor.
Object.
Admitted.
State rests and closes, Your Honor.
Mr. Mills?
Rest and close.
All right, then, Mr. Webb, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court's going to defer making any finding, follows the plea bargain, considers that CR 20-0709-3 and punishing you, places you on 3 years community supervision. You do have 125 days credit. As to any sentence you may eventually have to serve, and orders you to pay your attorney's fees, court costs, lab fee, and abide by all the regular and special terms and conditions of probation. Mr. Webb, have you ever been on probation?
No, sir.
Well, there are a lot of things you have to do and a few things you can't do while you're on probation. Do you know what can happen to you if you violate any term of this probation?
Yes, sir.
What can happen? It's what can happen is you're absolutely right. If you violate even one term or condition, a motion would be filed, a warrant would be issued for your arrest, you'd be brought back, you'd be placed in jail, brought back before the court. If at a hearing, the court found it true that you violated even one term or condition, the court could find you guilty, revoke your probation, and sentence you up to 24 months state jail. You understand?
Yes, sir.
And do you know how state jail time is served? Generally speaking, day for day. That's right. All right, sir. Good luck to you. You need to see Mr. Well, no, you don't. It's deferred. You need to see probation before you leave.
That's all I have. My excuse.
Yes, sir. Appreciate you. Mr. Lowry, you passed your test. You're free to go. We'll see you in your next setting. Yes, sir. Yes. Mr. Green.
Ready for plea on Amanda Baldwin.
Okay. All right. This is cause number CR 21-0231-392, the state of Texas versus Amanda Shea Baldwin. And this was set for status today. However, a plea has been presented to the court. Is the state ready?
Yes, Your Honor.
On behalf of Ms. Baldwin?
We're ready, Ron.
Right, ma'am, is your name Amanda Baldwin? And are you the same person that was originally indicted by a Henderson County grand jury for this second-degree felony offense of possession of a controlled substance? Can I get you to raise your right hand, please? You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
Now you can lower your hand. Ms. Baldwin, can you read and write the English language? Are you a U.S. citizen? If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that? And Ms. Baldwin, have you ever been treated for any mental health or emotional issues?
yes.
All right, have you been diagnosed with anything?
Bipolar.
Okay, are you taking any medication for that? Do you need to be? Probably, huh? Well, do you understand what's going on in here?
Yes, I understand.
I know what's going on. Do you understand? I hope I know what's going on. You know what's going on? Okay.
Yeah.
And Mr. Green, do you believe your client is competent?
I do, Your
I
Honor.
am.
All right, well, Ms. Baldwin, no. You're gonna talk me into feeling that you're competent in a minute. No, Ms. Baldwin, seriously though, based upon, the law presumes you're competent. And even though you told me you're not taking any medication and you think you need to be, based upon your answers to my questions, your demeanor in court, and the statement to your attorney, I find you are competent. Now, Ms. Baldwin, I know that we've already arraigned you on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
No, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a second-degree felony, which carries a punishment range of not less than 2 years or more than 20 years in the Texas Department of Criminal Justice, and a fine of up to $10,000. Do you understand the range of punishment
Yes, sir.
in the plea bargain?
The state is recommending 10 years probated for 7 years, 21 days towards any future sentence, $2,000 fine, $365 court costs, $180 lab fee, and all special and standard terms and conditions of probation to include staying away from the Walmart in Gun Barrel City.
Why?
That's where the criminal trespassing that we're taking into consideration occurred at.
Oh, I see it now.
And-
Okay.
And also, so when she's arrested for criminal trespass, is where they found a controlled substance.
Understood. I try to stay away from the Walmart in Gun Barrel City too. There's real live zombies in there, trust me.
I do.
All right, and so Ms. Baldwin, is that your understanding of the plea bargain?
Yes, sir.
And Mr. Green, is that your
It
understanding?
is, Your Honor.
Well, Ms. Baldwin, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back of that document, Mr. Green?
Yes, sir, I did.
And did you sign it?
Yes, sir.
Do you have any questions about it? The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document with you? And did you sign that second page there? Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with Mr. Green? Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
Do you want to waive your right to a jury trial and do this plea bargain?
Yes, sir.
And I'll ask you, man, how do you plead to that second-degree felony offense of possession of a controlled substance? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes, sir.
I'll hear the evidence.
State presents states one, the incident report, states two, Michael Warren compliance, and states three, lab report, Your Honor.
No objections.
Admitted.
State rests and closes, Your Honor.
Rest of closed, Judge.
All right, Ms. Baldwin, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that felony offense contained within the indictment. The court will follow the plea bargain, considers those unindicted cases in sentencing you, sentences you to 10 years in the Texas Department of Criminal Justice. However, the court will probate that, place you on community supervision for 7 years. Excuse me. You do have 21 days credit as to any sentence you may eventually have to serve. In order for you to pay your fine, attorney's fees as well, attorney's fees, court costs, and the lab fee. And let's see, we didn't have attorney's fees in there. I'm gonna write it.
You got the number right, Judge. It's 975.
Okay. Yeah. And let's see, and abide by all the regular and special terms and conditions, including staying away from the Walmart in Gun Barrel City.
Yes, sir.
And Ms. Baldwin, have you ever been on probation before? Did you successfully complete it?
No, but I was like, I was really young.
You're really young. Well, what happened after you didn't complete it?
I went to prison
For how long?
13 months,
Right, you know how long you can go to prison if you violate this?
2 years.
Up to 10 years, that's correct. Here's what can happen. If you violate any term or condition of this community supervision, a motion would be filed. A warrant would be issued for your arrest. You'd be brought back before the court. If at a hearing, the court found it were true that you violated even one term or condition, the court could revoke your probation and sentence you up to 10 years in TDC. You understand that?
Yes, sir.
So would you agree with me? It's extremely important you abide by these.
Yes.
I hope you do, man. Good luck to you. You need to see Mr. Halbert to your right. And now that you've been finally convicted, you are now under Texas law and eligible to possess a firearm or ammunition. If you have any questions, consult an attorney.
Yes, sir.
Good luck. You need to see Mr. Halbert and probation before you leave. You're letting your exhibit stack up over there. It's all here?
James Stockwell, the second for a plea.
Now, give me a minute. Let me sign them real quick. That way Melanie can get her paperwork over there. Yeah, I did. Mhm. Wonder why I didn't sign the affidavit. Okay, is my preset bond on it? Okay. I'm just catching up on signatures here, Mr. Sockwood. Give me just a second. I'm sorry? I understand. Sorry, I didn't see you right. All righty, this is cause number CR 21-0453-392, the state of Texas versus James Randolph Sockwell. This was set for status today. However, a plea has been presented to the court. Is the state ready?
Yes, Your Honor.
And on behalf of Mr. Sockwell,
We are ready.
right, sir, is your name James Randolph Sockwell? Yes, sir. And are you the same person that was indicted by Henderson County Grand Jury in this third-degree felony offense of PCS? Yes, sir. If I can get you to raise your right hand the best you can, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. You can lower your hand. Mr. Sockwell, can you read and write the English language? Are you a U.S. citizen? If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that? Mr. Sockwell, have you ever been treated for any mental health or emotional issues? Do you understand what's going on in here? Ms. Altier, do you believe your client is competent?
I do, Your Honor.
The court finds that he is. Mr. Sockwell, I know that we've already arraigned you on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom? But do you understand the charge? Well, as indicted, that charge is a third-degree felony, which carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice, and a fine of up to $10,000. Do you understand that range? In the plea bargain?
The state is recommending 5 years TDC with a credit for 122 days served, $975 attorney's fees, $365 court costs, $180 lab fee. And this would be taking in consideration of possession of controlled substance between 1 and 4 grams and a possession of marijuana under 2 ounces from July 20th, 2021.
Is that your understanding of the plea bargain, Mr. Sockwell? And is that your understanding, Ms. Altier?
It is, Your Honor.
Well, Mr. Sockwell, a few minutes ago, you told me you could read and write the English language. I want to go over a couple documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and back of that document with Ms. Altier? And did you sign the front and the back? Do you have any questions about it? The next document I'm going to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document? Yes, sir. And did you sign that second page there? Do you have any questions about it? Do you have any questions about any of the documents that you read and went over with her? Well, if you read and went over these with her, I know she explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial? You want to do this plea bargain? And I'll ask you, sir, how do you plead to that third-degree felony offense as charged in the indictment? Guilty or not guilty? And are you pleading guilty because you are and for no other reason? I'll hear the evidence.
State presents States Exhibit 1 offense report, States Exhibit 2 Michael Moore compliance, and States Exhibit 3 lab report, Your Honor.
We have reviewed with no objection, Your Honor.
Admitted.
State rests and closes, Your Honor.
Defense rests and closes.
All right, Mr. Sockwell, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that third-degree felony offense as charged in the indictment. The court will follow the plea bargain, takes in consideration this misdemeanor and felony charge on the agreed plea recommendation sheet, sentences you to 5 years in the Texas Department of Criminal Justice with credit for 122 days, and orders you to pay your attorney's fees, court costs, and lab fee. And a couple more things before you go, Mr. Sockwell. Did you get an opportunity to review the judgment in your case? Was your name, the charge, and the time credit correct? All right, sir. Now that you've been finally convicted of this felony offense, you are now under Texas law and eligible to possess a firearm or ammunition. If you have any questions about that, consult an attorney. You're now remanded back to the custody of the sheriff for transport to TDC. Good luck to you, Mr. Sockwell. Need to see Mr. Halbert before you have a seat.
Your Honor, I have a Zachary Crawford. I told him to wait outside. You want me to get him now? It's for a plea. I'll call him Zachary Crawford.
Sure, Zachary Crawford. You're going to go get him? Ronnie would have done it. Well, you're all right. He doesn't mind. I threw in some double-sided paperwork there to throw me off there, but that's all right. I got it. All right, this is cause number CR 19-0517-392, the state of Texas versus Zachary Nathaniel Crawford. And this is set for a plea today. Is the state ready?
State is ready, Your Honor.
And on behalf of Mr. Crawford.
Defense is ready, Your Honor.
All right, sir, is your name Zachary Nathaniel Crawford? And are you the same person that was originally indicted by a Henderson County grand jury for this third-degree felony offense of assault family violence? I get you to raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. Roll your hand. Mr. Crawford, can you read and write the English language?
Yes.
Are you a U.S. citizen?
Yes.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes.
Mr. Crawford, have you ever been treated for any mental health or emotional issues?
No.
You understand what's going on in here?
Yes.
And Ms. Altier, do you believe your client is competent?
I do, Your Honor.
The court finds that he is. Mr. Crawford, I know we've already arranged you on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom? But do you understand the charge?
Yes.
Well, as originally indicted, that charge is a third-degree felony, which carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand that range?
Yes.
However, it's my understanding that in exchange for your guilty plea, the state's willing to recommend that the court convict you as a state jail felony, which carries a punishment range of not less than 2 years or more than 180, not less than 180 days or more than 2 years in a state jail felony facility and a fine of up to $10,000. Do you understand that range?
Yes.
And further, they're asking the court in exchange for your guilty plea to punish you under 1244A of our penal code, which allows for a state jail to be punished as a Class A misdemeanor. A Class A misdemeanor carries a punishment range of not more than 1 year in the county jail and a fine of up to $4,000. Do you understand all those ranges in the plea bargain?
Yes, Your Honor. In exchange for a plea of guilty, the plea recommendation is to reduce it to a lesser included attempted assault family violence. This is a state jail felony, but punish it as a 1244A, 180 days in the Henderson County Jail with time credit of 107 days as of today, $1,000 fine, $750 attorney's fees, and $249 in court costs.
And the complaining witness,
Yes, has been notified.
and are they on board with the plea bargain?
No response, Your Honor.
Okay. All right. Is that your understanding of the plea bargain, Mr. Crawford?
Yes.
And is that your understanding, Ms. Altier?
Actually, the fees were 2,250 because I had included trial preparation. We were set for trial in this case.
That's what I have on my plea sheet. I might not have caught it when you read it. Usually I do.
Yeah.
All right. And so that's everybody's understanding of the plea bargain?
Yes, Your Honor. Yes, Your Honor.
All right. Well, Mr. Crawford, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back of that document with
I
Ms.
did.
Altier?
Yes.
Do you have any questions about it?
No.
Did you sign the front and the back?
Yes.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both the front and back of that document?
We did.
And did you sign the back of it?
Yes.
Any questions about it?
No, sir.
Any questions about any of the documents that you read and went over with Ms. Altier?
No.
If you read and went over these with her, I know she explained to you. You said he was on the trial docket. Was he just on that last one?
Yeah, he was.
Okay.
He's
And-
been on the trial docket since January 2020.
Okay, and so then I know she explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No.
Do you want to do this plea bargain? Then I'll ask you, sir, how do you plead to that lesser included offense of that which is charged in the indictment, the attempted assault family violence by impeding breath? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are for no other reason?
Yes.
I'll hear the evidence.
Yes, Your Honor. State offer states exhibit 1, the offense report, and state exhibit 2, discovery compliance.
We have reviewed with no objection, Your Honor.
Admitted.
State rests and closes.
Defense rests and closes.
All right, Mr. Crawford, then based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that lesser included offense, the attempted assault family violence by impeding breath. The court will follow the plea bargain, punishes you under 1244A of our penal code, sentences you to 180 days in the Henderson County Jail with credit for 107, orders you to pay your fine, attorney's fees, and court costs. And let's see, Mr. Crawford, a couple more things. Did you get an opportunity to review the judgment of conviction in your case?
Yes.
Was your name, the charge, and the time credit correct?
Yes.
All right, sir, and now that you've been finally convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition If you have any questions about that, consult an attorney. Is he going into custody today? All right, sir, you're now remanded to the custody of the sheriff to serve out the remainder of your sentence. Good luck to you, sir. Need to see Mr. Halbert before you have a seat, though.
Nothing further yet.
Yes, ma'am. Thank you. Ms. Moore.
No, I was just gonna turn it on the line.
Oh, sorry. Yeah, I've got him right here. See that when you get a chance, the docket sheet on this lane. Porter Lane, come on up. That's okay. I'm going pretty fast here. All right, it's cause number CR 21-0427-392, the state of Texas versus Porter Warren Lane, based upon Mr. Lane's charge, as well as the fact that he had tested positive back in June, ordered the defendant to take a drug test today, and he has tested positive for methamphetamine.
And Your Honor, Mr. Lane denies use, and we would request that this be sent off for confirmation, and the court defer any ruling regarding his bond until such time as the sample could be confirmed.
Well, Mr. Lane, normally when somebody tests positive for methamphetamine but not amphetamine, I'll go ahead and do that. But if this confirms positive, I'm going to see you again and we're going to talk about it. Understand? All right, well, I'm going to send it off for confirmation. You're still on conditions of bond. When's he reset?
November the 4th.
And we'll see you on November the 4th and we'll go over whatever comes back. All right.
May we be excused?
Yes, ma'am. Thank you. Yes, sir. I got you. All right. This is cause number. It's okay. It's for me. Tell them I'm on the bench. I'll call them back. It sounded like the morning Muslim call for prayer. I thought he opened the door and I heard it. And gave me a flashback. All right. CR 21-0326-392, the state of Texas versus Amy Marie Bookman. And this is set for a plea today. Is the state ready?
Yes, Your Honor.
And on behalf of Ms. Bookman.
Your Honor, Matt Thomas, have Ms. Bookman present, ready.
All right. Ma'am, is your name Amy Marie Bookman? And are you the same person that was originally indicted by Henderson County Grand Jury for the state jail felony offense of driving while intoxicated with child passenger? And get you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. Lower your hand. Ms. Bookman, can you read and write the English language? Are you a U.S. citizen? If it turns out you're not, when you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that? And Ms. Bookman, have you ever been treated for any mental health or emotional issues?
Anxiety.
All right. Are you on any medication for that?
Yes, sir.
Okay. And are you taking it as prescribed?
Yes, sir.
Mr. Hawkins, do you believe your client is competent?
I do, Your Honor.
The court finds that she is. Ms. Bookman, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom? Well, it's up to you. Okay, I have to make sure you understand what you're charged with. But you do understand what you're charged with. Well, you are charged with a state jail felony, which carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine of up to $10,000. Do you understand the range of punishment? In the plea bargain?
The state is recommending 2 years, 2 years probated for 3 years, with credit for 1 day served, a $2,500 fine to be paid today, $399 court costs, $128.50 in lab fees, and 10 days as condition of probation.
All right, is that your understanding of the plea bargain, Ms. Bookman? And is that your understanding, Mr. Hawkins?
It is, Your Honor.
Well, Ms. Bookman, a few minutes ago, you told me you could read and write the English language. I'm going to go over a couple documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back of Mr. Hawkins? And did you sign the front and the back? Do you have any questions about it? The second document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document with Mr. Hawkins? And did you sign that second page? Do you have any questions about it? Do you have any questions about any of the documents that you read and went over with him? Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial? Do you want to do this plea bargain? And I'll ask you, ma'am, how do you plead to that state jail felony offense of driving while intoxicated as alleged in the indictment? Are you guilty or not guilty? And are you pleading guilty because you are and for no other reason? I'll hear the evidence.
State presents states 1 offense report, states 2 Michael Martin compliance, and states 3 lab report, Your Honor.
No objection, Your Honor.
Admitted.
State rest and closure, Your Honor.
No rest and closure, Your Honor.
All right, Ms. Bookman, then based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that state jail felony as alleged in the indictment. The court will follow the plea bargain, sentences you to 2 years in a state jail felony facility. However, the court will probate that, places you on community supervision for 3 years. You do have 1 day credit as to any sentence you may eventually have to serve, and orders you to pay your fine, court costs, and abide by all the regular and special terms and conditions of probation, including that 10 days in the Henderson County Jail as a condition of that. And Ms. Bookman, have you ever been on probation before?
Probably 20 years ago.
Okay, what was it for?
$250.
Okay, and did you successfully complete it?
Yes, sir.
You know what can happen if you don't successfully complete this community supervision? What can happen? For how long?
2 years.
And you know how state jail time is served? Generally day for day, and you only have 1 day credit. Here's what can happen. If you violate even one term or condition of this community supervision, a motion would be filed, a warrant would be issued for your arrest, you'd be placed in jail, held without bond, brought back before the court, and if at a hearing, the court found it true that you violated even one term or condition, might ought to silence
Sorry,
that.
that's a word.
If the court found it were true that you violated even one term or condition, the court could revoke your probation and sentence you up to 2 years in state jail. So would you agree with me? It's extremely important you abide by these terms. I hope you do. And before you go, Ms. Bookman, now that you have been convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions about that, consult an attorney. Good luck to you, man. You need to see Mr. Halbert over here, and then you'll see probation before you leave.
Thank you.
Yes, sir. Good to see you.
Good to see you, Judge.
She's done on weekends. Yeah, I looked at 5 minutes. Well, that was for.
Yeah, I know.
You gotta answer out loud, sir.
No, sir.
All right. Well, do you understand the charge? Well, as indicted, that charge is a third-degree felony, which carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand the range of punishments? In the plea bargain?
The state is recommending 10 years, probated for 10 years, $2,500 fine, $305 court costs, all special and standard terms and conditions of probation, including 30 days as condition of probation.
Is that your understanding of the plea bargain, Mr. Eaton? And is that your understanding, Mr. Johnson?
Yes.
Well, Mr. Eaton, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back of that with Mr. Johnson?
Yes.
And did you sign it?
Yes, sir.
Do you have any questions about it? The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you go over both pages of that document with Mr. Johnson?
Yes, sir.
And did you sign the second page?
Can we have just a second?
Yep. Oh, you're good.
Actually, can I have just?
Sure, go ahead.
2
You might
minutes
want to catch him up on what y'all are talking about. Let's go off the record.
Probably gonna need that paperwork back. I think there was a condition law,
What is it?
30 days condition of probation.
You want me to write it in there?
Yes.
We'll need a confinement order. Well, that's a showstopper. While he's doing that, and we're off the record. Let me see. We just have one more, is that right? Okay, and that's gonna be a plea? Boy, the day didn't start out looking like we were gonna get anything moved, but sure ended that way. Tell you what.
18.
Did you say 18 or 18?
18.
18? Oh, A, alpha.
Oh, wait, I mean, yeah.
What'd y'all say the name of that prosecutor coming was? Chris Kane.
Yes, sir. Could be him. I believe he starts in November.
Say again over?
I believe he starts in November.
What'd you say?
Now I know more than us.
I don't know anything, but I like to know who people are before they appear.
She didn't hear that.
Treat you like a mushroom, huh? Keep you in the dark and feed you on, you know what?
That's what you told me. Oh, yeah.
Depends which office she has.
Mass production. Assembly line. All right, let's go back on the record and cause number CR 21-0172-392. State of Texas versus Douglas Cole Eaton. During the admonishments of the defendant on his constitutional rights and this plea bargain, the attorney for the state and Mr. Johnson, the attorney for Mr. Eaton, consulted, and Mr. Johnson needed to consult with Mr. Eaton. And are we now ready to proceed?
Yes, Your Honor.
Is there anything changed on the plea bargain?
We added 30 days as condition of probation, which was part of the agreement, but not on the paperwork.
All right, and so we'll back up a little bit, Mr. Eaton. And so you understand that, I guess, the original deal that the state had was that in addition to this probation, you'd have to complete 30 days in the Henderson County Jail. I got you answered. Yes, sir. Okay, and you're okay with that? Well, I won't say you're okay with that. Are you agreeing to do that as part of this plea bargain? Yes, sir. All right, and when's he going to report?
He has a confinement order right here.
All right, and then Mr. Johnson, that's your understanding of this addendum to the plea bargain?
It is, Your Honor. I had to explain it to Mr. Eaton, and that's our agreement.
Okay, all right, well, Mr. Eaton, I left off, I was going over this court's admonishments and warnings document with you. And I think you told me that you went over both pages of that with Mr. Johnson, is that correct? And you signed that second page. You have any questions about it? You have any questions about any of the documents that you read and went over with Mr. Johnson? Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial? You want to do this plea bargain? Then I'll ask you, sir, how do you plead to that third-degree felony offense of unlawful possession of a firearm by a felon as alleged in the indictment? Guilty or not guilty? And are you pleading guilty because you are and for no other reason? I'll hear the evidence.
State presents states 1 offense report and states 2 Michael Morton compliance, Your Honor.
Admitted.
State rests and closes, Your Honor.
All right, Mr. Eaton, then based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that felony offense as alleged in the indictment. The court will follow the plea bargain, sentences you to 10 years in the Texas Department of Criminal Justice. However, the court will probate that, place you on community supervision for a period of 10 years. You do have 2 days credit as to any sentence you may eventually have to serve, and orders you to pay your fine and court costs and abide by all the regular and special terms and conditions of community supervision, including that 30 days in the Henderson County Jail as a condition. And Mr. Eaton, I think that's all I have for you. You ever been on probation before? Did you successfully complete it?
Yes, sir.
You know what can happen if you don't successfully complete this probation?
Spend up to 10 years in prison.
That's right. Here's what can happen. If you violate even one term or condition, a motion could be filed, a warrant would be issued for your arrest, you'd be placed in jail without bond, brought back before the court, and if at a hearing, the court found it true that you violated even one term or condition, the court could revoke your probation and sentence you up to 10 years in the penitentiary. Understand that? Well, good luck to you, sir. You need to see Mr. Halbert before you leave and visit with probation.
Thank you, Judge. Maybe.
Yes, sir. Good to see you.
Close it, sir.
No, he was going, when was he going?
October 31st.
October 31st. Make sure you report on that day or you could catch another charge, and bring that paper with you. They won't let you in without it.
I think we're ready on Mr. Frank.
Yes, sir. I'm just waiting on paperwork and we'll get started. That's okay. I'm not in a hurry. I'll have to be in Malakoff till really about 7 o'clock. My freshman's playing JV game over there. He said, I don't care if we don't win another game all season. I want to beat Malakoff. Of course, Ryan and them play the varsity tomorrow night. They're not the team that they were, but they're. All right, this is cause number CR 21-0329-392. The state of Texas versus Murray Clayton Frank. And this was set for status today. However, a plea on 2 counts of the indictment has been presented to the court. Is the state ready?
Yes, Your Honor.
And on behalf of Mr. Frank,
We're ready, Judge.
make sure is your name Murray Clayton Frank?
Yes, sir.
And are you the same person that was originally indicted by a Henderson County grand jury for both of these 3rd-degree felony offenses contained in counts 1 and 2 of that indictment?
Yes, sir.
And get you to raise your right hand the best you can, please. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
And you can lower your hand. Mr. Frank, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Right.
And Mr. Frank, have you ever been treated for any mental health or emotional issues? Do you understand what's going on in here today?
Yes, sir. I do.
And Mr. Green, do you believe your client is competent?
I do, Your Honor.
And the court finds that he is. Mr. Frank, I know that we've already arraigned you on this case. However, would you like the prosecutor to read each of these counts in the indictment out loud here in the courtroom? but do you understand the charges?
Yes, sir.
Well, as indicted, each of those counts is a third-degree felony, which carries a punishment range of not less than 2 years nor more than 10 years in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand that range of punishment? And further, are you all abandoning the enhancement paragraph or is he plea? Yeah.
It's, we're not entering a plea to the enhancement.
We're not changing it. and then-
No, we're not pleading to it. No, that's just a straight third degree.
So are you
So then we
abandoning?
would be abandoning.
Okay, I just want to make sure. Well, Mr. Frank, they do have an enhancement paragraph alleged, and if you were to go to trial in this case and be found guilty beyond a reasonable doubt at punishment, if that enhancement paragraph were proven true, then the range of punishment would be not less than 2 years or more than 20 years in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand the range of punishment?
Yes, sir.
In the plea bargain?
The state is recommending 6 years TDC with credits for 253 days served, 1,050 attorney's fees on count 1 and $355 court costs on count 1. On count 2, there would be an additional $150 attorney's fees. And this would be taking into consideration count 1 and 2 of cause number CR 21-0330-392.
Is that your understanding of the plea bargain, Mr. Frank?
Yes, sir.
Is that your understanding, Mr. Green?
It is.
Well, Mr. Frank, a few minutes ago, you told me you could read and write the English language. I'm going to go over a couple documents with you. The first is the agreed plea recommendation. Now, there's one of these for each count in the indictment. Did you read and go over each one of these with Mr. Green?
Yes, sir, I did.
The front and the back?
Yes, sir.
And did you sign the front and the back of each of those?
Yes, sir, I did.
Do you have any questions about it?
No, sir, I don't.
The next document I'm going to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. And this applies to each of these counts. Did you read and go over those with Mr. Green?
Yes, sir, I did.
And did you sign the second page there?
Yes, sir, I
Do you have any questions about it?
did. No, sir.
Do you have any questions about any of the documents that you read and went over with Mr. Green?
No, sir, I don't.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No.
Okay.
No.
Do you want to do this plea bargain?
Yes, sir, I do.
Then I'll ask you, sir, how do you plead to count 1 of that indictment, that third-degree felony offense of forgery of a financial instrument?
Guilty, Your Honor.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
And that in that same cause number, how do you plead to count 2, that third-degree felony offense of fraudulent use or possession of identifying information?
Guilty.
And are you pleading guilty to that count because you are guilty and for no other reason?
Yes, sir.
I hear the evidence.
State presents the offense report as states 1 and Michael Moore compliance as states 2, Your Honor.
No objection.
Admitted.
State rest and closes, Your Honor.
Rest closed on.
All right, Mr. Frank, and based upon your guilty pleas in each of these counts, the court has enough evidence to find you guilty and does find you guilty of count 1 and also finds you guilty of count 2. The court will follow the plea bargain, sentences you to 6 years in the Texas Department of Criminal Justice in each case. And of course, these will run concurrently. In sentencing you, the court has considered CR 21-0330-392, counts 1 and 2. Orders you to pay your attorney's fees and court costs in each count. And I think I handled everything. And let's see, Mr. Frank, before you go, have you had an opportunity to review the judgment in each of those cases, each count?
Yes, sir, I
In
have.
each of those, was your name, the charge, and the time credit correct?
Yes, sir.
All right, sir, you're now remanded back to the custody of the sheriff for transport to TDC to serve out your sentence. Good luck to you, sir.
You have a great day.
You too. You need to see Mr. Halbert before you leave.
I think that states motion to expand.
Okay, thank you.
That's all my business.
Yes, sir. Appreciate you.